Welcome to Solving Citizen Legal Encounters. Today we're finally here, okay? Part 3 of the jury trial. Everybody's been waiting for it, and it is good, I'm going to say. Eric Martin really shows his 28-year law experience and everything that he knows right in this trial, okay? So I'm not going to hold you up. We can ready to get right into it. Don't be surprised. I may say a couple things in this one. I was quiet on the last two. But this guy in this one, yeah, you're going to love it. All right, let's get to it.
Mr. Martin, any witnesses?
Well, I did want to bring a witness, and then besides the hearing officer issue, I already ruled on that.
Sir, the hearing officer from the city of Livonia who denied your license one time ago has no relevance to this case.
I don't want to explain why, but
it doesn't. It doesn't have any relevance to this case, so I can't bring in anything that's not relevant.
He told him that in the other part. I think part 2. Now he's pushing his luck already.
Any further discussion is going to try to possibly make a mistrial out in contempt of court. So say another word about it.
Oh, here comes the contempt.
You're going to have to advise Mr. Martin of his Sixth Amendment rights, which I think he's now fully aware of. His knowing and voluntary decision that he would like to take the stand on his own behalf. At this time, Mr. Martin will be calling Mr. Martin to the stand, and I will be asking a couple questions.
Okay, so just for the record, I'm not going to allow Mr. Martin to just testify in some sort of narrative form. He's going to be asked questions by you. Is that how it is?
Yes, sir.
Okay. And Mr. Martin, you understand that you are subject to any cross-examination by the prosecution if you take the stand. You understand that?
no, comprehend that.
All righty. And sir, you understand knowingly and voluntarily that you are choosing to take the stand, knowing that you have the right to remain silent, not have that silence used against you. You understand that?
Yes.
Okay. And counsel, as a co-counsel here, has explained all of that to you. Is that correct?
Yep.
All right. And Mr. Martin, you may take the stand, sir. I find that you're knowingly and voluntarily doing so.
Sir.
Yeah, he said Mr. Martin is going to take the stand for Mr. Martin.
Madam Recorder, I'll stay put at the podium this time for us.
Mr. Martin, do you solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
You may be seated, sir. Please use a nice outside voice close to the microphone so that we can make sure that we make a good record that everybody can hear. All right?
All right. Please state your full name for the record.
Capital E, lowercase r-I-C, of the capital M, lowercase a-r-t-i-n family. Living private man, known as sovereignty, as the U.S. Supreme Court recognizes, not a corporation, legal fiction entity. It's being fraudulently acted on as if I am.
Where were you on July 11th of 2023 at approximately 4 p.m.?
Riding my traveling by right on my moped, about to cross the street of North Line, and I do not remember. Well, give my time. I might just stick strictly with your question. Elaborate more, or just.
Let me prompt you to say, can you tell me a little further about what happened that day?
I was traveling by right on my moped. I wasn't carrying passengers of property for hire at the time. So therefore it meets the definition of travel by right. I do not remember stopping at getting off and impeding traffic. I do not remember myself doing that.
Mr. Martin, what do you recall the condition of your rear tire being that day?
My tire did go flat on me when I remember it when I crossed North Line Street. A short distance, the tire had just went flat, and I stopped the moped. It went flat. That's it. And this one, and it was a short distance. I'm thinking roughly 50 feet, maybe 100 feet. It wasn't long, but it's like any flat tire, you gotta stop so don't damage my rim. But so I stopped, and but also during this is when Anthony Borg.
I'm gonna ask you another follow-up question. So why don't you tell us, when you first recall seeing the officer?
Once I crossed the North Line, it was just a little bit past that. Anthony Borg was there, another one of his partners, and he called me over. He said, "Hey, come here." So when he said that, I figured I'm under threat of arrest to stop, because if I don't, he may try to arrest me or write some ticket like obstruction of justice or something. So under threat of arrest, not willingly, contractually, I stopped against my consent. And this is when the rest followed. As he said, he arrested me and he forced my identification from me, which again, I did not willingly do. I figured if I didn't give him my ID, it's going to be, a charge of obstructions. I've been seeing YouTube videos, people get charged by cops sometimes is they don't give their ID. They don't self-incriminate yourself, basically. They get charged with obstruction of justice. So under that threat of arrest, I gave my ID home.
Mr. Martin, let me ask a better question. Would you like to describe any of the characteristics of the device that you were on that day? You asked some questions previously about the vehicle. Is there anything that you think is relevant for us to know about this vehicle?
Well, the burden of proof is on the prosecutor. So I'm silent on that. Burden's on them.
Understood, Mr. Martin. Factually, is there anything that you would like the jury to know about the vehicle or the moped? It's your opportunity to sort of explain any of the facts that you...
No, except for I was traveling by right, regardless of what it is. It's not important, as I was shown by the law, whether it had an electric motor or a gasoline motor, whether it was called, I don't think I'm going to prove in my argument how it was irrelevant anyways. Like I said, the burden of proof is on the prosecutor, not me, so I remain silent on that issue.
Your Honor, as this is a little bit unusual way to have a direct examination, I would like to ask an open-ended question. I understand that we can't just go for a full narrative, but Mr. Martin.
And I object to that extra question too, because it would be self-incriminating, even if, hypothetically, if it wasn't.
Understood.
Right.
What?
Okay, then that's why we're giving you an opportunity to clear that up right now. This is your chance, Mr. Martin. I don't have any more direct questions for you right now. Was there anything else that you would like to tell the jury at this time, factually, about what happened on July 11th of 2023 at approximately 4 p.m. thereafter, immediately after?
Well, yeah, also Anthony Borg had no legit reason for pulling me over. He seen me, he pulled me over. He was going, as his testimony said himself, he just noticed me from prior experience. Now, that is not a justified reason to pull me over. To just go by and say, okay, in fact, let's say a year or two ago, I didn't have a driver's license. That doesn't mean I don't have one now, so you can't just go pulling people over because you think, because a year or two ago, the guy didn't have a license, so let's just pull him over again, let's just see. So this is why it's harassment to me, factual-wise, it supports that, and in my mind, that's what it is. And it's retaliation for my complaints. Yeah.
Mr. Martin, before I ask opposing counsel if he has any questions for you, is there anything else you would like to tell us?
I do not know us right now.
Understood. I will have a chance when Mr. Greco's done to stand back up and do what's called redirect. So I will pass the witness at this time.
And that redirect will be only under the scope of cross-examination.
I'm sorry, and thank you for clarifying that.
Yeah.
All this.
Mr. Greco, cross-examination.
Mr. Martin, on the afternoon of July 11th, 2023, as you've testified, you were driving your moped on North Line Road near Heritage Park, correct?
No, not correct.
You didn't just testify about that?
Yeah, I didn't say I was driving. Did I use those words? No.
Were you traveling on your moped?
Traveling by road.
No, hang on a second. Were you traveling on your moped on July 11th around 4 o'clock on North Line Road?
I'll dispute that. Traveling by road.
Okay, thank you.
Same as driving.
Okay. When you were on the moped, right? This is not a Flintstones thing. You were like moving your feet. No, it was You just said it was a moped during your direct exam.
No.
It has a motor,
I did
correct?
not say that. No, I did not say that. I
You
said
keep
if it,
referring,
I'm gonna clarify, in case you misheard me, I says regardless whether it is or not, I remain silent on that issue because it's for the prosecutor's burden to prove. I don't, sit there and
After you
tell whether it's
indicated it was a
motorcycle, moped,
It's
a
okay.
electric bike.
and you were in the city of Taylor, correct?
Well, what's your definition of in the city of Taylor? Does that mean?
Okay,
subject to the corporation?
let's ask, you can answer my question. Do you know if you were in the city of Taylor that day?
Yes, I was.
Okay, thank you.
All right, I just want to understand, that does not.
No, it's okay. I just answered so you would understand it. Okay, so that's clear. We're good. Okay, and you just testified that you admit that at or around the time that Officer Borg pulled you over, that your tire was in fact flat, right?
It just went flat, yes.
Okay, regardless of whether it's on his body cam, it was in fact flat, right? So we can establish that?
Yes.
Okay. And you admit that you didn't have a valid driver's license that day, correct?
Yeah, I'm just, I didn't have a driver's license.
Okay, that's fine. You acknowledge that state law requires you to have a driver's license. You just disagree that it should be applicable to you, correct?
No, it's not correct. As my opening statement says, I do not, no, the state law does not mandate me as a human, as I will show with my legal arguments, to
I
have a
understand.
driver's license.
No.
And you're traveling by right, which is a difference by the law.
I understand. Listen
Driving is
listen to my question again. You acknowledge that the state law says that it requires to operate a motor vehicle on the road, you need a driver's
It's
license,
a
right?
fraud. No, it requires, it says the specific statute uses the word person, and as I will demonstrate, the US Supreme Court said persons are defined as, it's distinguished from a sovereign, one of the sovereign people. There's a difference. So it's really a corporation, it's all a fraud. What's really being charged is a corporation, all capital letters, names, which is not me as a human.
Your testimony that you're not a person
Is that I am a sovereign, one of the sovereign people, as the US Supreme Court said.
and
People are sovereign.
right, and your testimony is that because you're not a person, that you are not required under the laws of the state of Michigan to have a driver's license to operate a motor vehicle, correct?
That's right.
Okay, thank you. I have no further questions.
Any redirect
Questions?
under the small scope of the direct, cross-examination?
Don't ask him if he's a person.
I'm pulling over to inspect whatever condition your rear tire was in. You were able to still drive it off? Or were you able to still drive it off?
It went down flat, but, it went flat. And I can't remember if it was, went all the way flat. Actually, I think it has had a little bit more on there, but I won't feel safe sitting on it, but I could have walked away with it. And in contrast to the testimony that, the police officer said, for example, it was abandoned. That was a lie. So that's something else I want to mention too. I did not abandon my vehicle. No time it was private property. I did not abandon it. I could have walked away with it from the scene without traveling by right on it, or they want to call it driving. I didn't have to do none of that. So that's another reason why they didn't have to tow it. And regardless of the flat tire issue, I could have walked away with it anyways.
Mr. Martin, based on the questions that the prosecutor just asked you, I'm going to ask you an open-ended question because you're representing yourself today and I'm assisting you with the representation. Is there anything that you would like to state to the jury in response to the questions that Mr. Greco just asked, limited to that, nothing new, but limited to that area, as the judge is instructed?
Yeah, I'm going to say to the jury as to what the prosecutor said.
Correct. It's an open-ended question to you to, again, as you're representing yourself in this, anything else that you'd like to state on this matter?
Besides what I get to say in the argument, I can't. Well, actually, I do have some questions for the prosecutor. I need to get, I haven't written down.
No.
I don't know if these would be considered within the realm of direct examination. Do I have questions for the prosecutor? This has to do with a legal argument. Another one to dismiss this case, which has to do with your standing, Greco. Now, for example, one of them is.
Mr. Martin, I've already made a ruling on your motion to dismiss based on lack of standing, and I explained to you
This is totally
that I
different.
have jurisdiction and that the prosecution and the city of Taylor have standing.
This is a different argument based on standing. It's different.
Different argument based on standing.
No, but it's different.
Well, first off, if you're gonna make any sort of testimony while you're sitting there as a witness, it's gonna be about facts. If you have any legal argument that you wanna make, you can do that after your closing argument. After the prosecution closes their argument, you can ask that the jury be excused. You can make any motion that you want to at that time. I'll make that ruling, and then we can go back on the record with the jury. But sitting in the witness chair is not the time when you make a motion, when you're not going to be asking questions of the prosecutor, because he's not one of the people who you get to call as a witness.
The questions I have to ask them are relevant to a defense I have to raise. Some people don't have to raise it now.
Like I said, we'll do that outside of the presence of the jury, because we're not going to have the jury tainted by any sort of bias things you're going to be bringing up that are either frivolous or have nothing to do with the Constitution.
So let me ask a better question, perhaps, Your Honor. Mr. Martin, are there any other facts that you would like to tell the jury related to the questions that you just answered for the prosecutor?
Can't think of any. I reserve my right if I remember it later. I understand of any right now.
Nope. Just want to make sure that there wasn't anything we were leaving out. Your Honor, I have no further questions for Mr. Martin or any other direct at this time.
Sure. Mr. Greco, any further cross?
Nothing, Your Honor.
Hi, Mr. Martin, you may step down. And Mr. Martin, do you have any other witnesses to call?
Yes, like I said, I'd like to question Greco here. Yeah, he's one of my witnesses for some of the relevant defenses motions.
And you can't you can't call.
Right. Others are present and whatever.
You can't call opposing counsel as a witness. So.
But I think that is violating my due process.
It's not. It literally is not. Violate.
I thought Eric Martin was a 28-year law scholar.
Any of your due process whatsoever. So, do you have any other witnesses?
Oh, no. Defense rests our case.
Defense rests our case. Closing arguments. Mr. Greco?
Yes, Your Honor, very briefly, I'd like the jury to just a second, whether he is a person or a human being. I believe that the evidence showed that Eric Martin was traveling on a motor vehicle, a moped, in the city of Taylor on the late afternoon of July 11th, 2023, without a valid driver's license. In fact, the record here that you're going to be able to inspect is one. People's Exhibit number 1 shows that it was revoked. It says revoked at the top. You see the sanctions here from prior years, 2021, 2022, which pre-exist and predate the 2023, that it was in fact revoked. Regardless of this, he has admitted to you during his testimony that he did not have a valid license. He's admitted to you that the state of Michigan requires that persons are supposed to have a valid driver's license to drive on the road. He don't think that that applies to him. Once you hear the jury instructions, which he's already read to you, you're going to find the defendant guilty, and you should find the defendant guilty. There's no more case clearer than this. Thank you for your time. Do appreciate it.
And Mr. Martin, your closing argument?
Yes, I have a lot, so let's see. Start with. All right, and now she's showing this law to the jury here. So
First off, you're not going to show any law to the jury.
So I'm not allowed to show how I'm not
Listen,
guilty.
sir, listen. I'm going to tell you because I've told you 5 times. When it comes to the jury, their duty is to hear the facts, and it's my duty to instruct them on what the law is. I have right here. Sir, I teach constitutional law for 20 years. I know exactly what I'm talking about. So it is my duty to instruct them on what the law in this case is. And the law in this case is there are certain elements, 3 elements. 1, that the individual is traveling or operating a motor vehicle. 2, on a public road or access road. And 3, they didn't have a license at the time, or their license was either suspended, revoked, or denied. Those are the 3 elements. Those are the law that that's the law that I'm going to explain to them. Any other law that you are trying to show is not for the jury. not to hear from you, because you're not the one who has the duty to explain it to the jury. Okay? So if you think that you have a motion to dismiss, then this case would have already been dismissed. If your law that you wanted to point to was applicable, it would have already dismissed this case and we wouldn't even be in the jury trial. So if you want to make any sort of motions outside of the jury based on the law that you have in your hand, you're welcome to do so. I'll entertain said motion. But you're not going to be instructing the jury on this law here. Closing arguments is so that you can recap the facts and put your version of the facts on display at closing arguments. So if you'd like to do your closing argument, go ahead.
Well, this is part of my closing, so if I enter this as a mission, my legal arguments as exhibits, then don't I have the right to show them the law that supports that I am not guilty?
Sir, you have to follow the rules of evidence just like any other litigant has to. And all I am required to do is make sure that you have every opportunity to put on a fair trial. You had the opportunity to be cross-examined. You had the opportunity to remain silent. You chose to testify. Your own co-counsel asked you a series of questions. He even asked you a very open-ended question. Is there any other fact that you want the jury to know about the date and time of the incident in particular? And you said, nope, nothing at this time. So you had every opportunity to show any other facts that you wanted to.
So I'm okay then if you're
just saying this is the time. This is the time for your closing argument. This is where you recap the facts that were put into evidence. This is where you say things like, as the evidence showed, and then you say what your theory of the case is. This is not a legal argument. This is not a dissertation on legal philosophy. If you want to make that kind of motion, I'll do that outside of the presence of the jury so as to not taint the jury. You're literally tainting the jury right now just by attempting to do so. And if you continue, I'm gonna.
Maybe very briefly, Your Honor. I know we're to the end. This is kind of changed it.
He's about to put him in contempt of court because he keep explaining the same thing over and over again. I want to show him the law. I want to show him the law. You already seen it. I'm just commenting on it. It makes no sense. This guy doesn't listen.
Your Honor, after having the opportunity to consult with Mr. Martin, explain to him what a motion for directed verdict would entail, Mr. Martin would like to address this court with a motion at this time.
Okay. I'm going to ask the jury to stand up. All rise. I'm going to ask the jury to follow Officer Rose into the hallway and have a seat in the benches out there so we can come back. All right, so the jury is out of the presence, and the prosecution has rested. Are there any motions?
Your Honor, just going to make a record real quick. So Mr. Martin has been advised by co-counsel that legal precedent is not going to be put forth through direct or cross-exam testimony, that this is the proper avenue and the proper time to make his legal arguments. And so he understands that, again, I shouldn't say what he understands. I've advised him that that's what this motion is for. This is the proper venue, and that's where we're at. Mr. Martin, would you like to make your
Mr. Martin, you're making a motion for a directed verdict, is that correct?
Yep.
Okay.
Mr. Martin, I've advised him that his burden starts with people have not, or his argument starts with the people have not met their burden, and he's now to explain to the court what legal authority he has that supports that based on what we've heard today.
Very good. Mr. Martin, a very, very sound foundation has been laid for you by co-counsel. Please proceed.
As the testimony, the board admitted he did not know whether what I was traveling went 30 miles an hour or not, up to 30 miles an hour or more, and does not exceed 100 cc. He admitted that he did not know that. That is both of them elements. Actually, only takes one of the elements, but he admitted to both of them elements. He didn't know whether they exist. Both of them elements are necessary to exist to meet the definition of a moped under MCL 257.32b, which makes it clear that is the definition of a moped. One, it must go at least 30 miles an hour. Two, does not exceed 100 cc. He doesn't know, as he admitted, don't have evidence. So there's no evidence that it was even a moped. Therefore, the charge must be dismissed on that alone. And I have more.
All right, so let's do this for the sake of appellate representation and argumentation. You say you have more. So let me make rulings as to each of those so that the appellate court can take one, do what they want. Because, like, for example, if they overturn me on that first one, there's no point to go and do anything with the rest. So with regard to the fact that you say that this case should be dismissed because the evidence did not show that it was a moped. The evidence clearly showed that it was a moped because, one, Officer Borg said he was driving a moped. Officer Borg is a person who I don't know any person who couldn't recognize a moped. Now, you're talking about what is the legal definition of a moped that you can find in some statute. Sure, I get that. Whatever. Well, there's some statute that says things that just if you can do 30 miles an hour and you have this many cc's or whatever, we'll call it a moped. But I also just need testimony. All I need is testimony from a competent individual who has knowledge of the same, of what a moped is. He was asked, did you recognize? Yeah, it's just a common moped as you would commonly know or refer to as a moped. So for that reason, that specific motion to dismiss, a motion for directed verdict is denied. On to your next one.
I'd like to say something responsible, but I don't know. Say something
And you'll have that opportunity to do so on appeal, sir.
all right, well, next. Well,
Your Honor, if I may just address it briefly.
I'm sorry.
Was it all right?
I ruled that.
Okay, fine.
It was clear testimony by Officer Borg.
Yeah.
That he recognized it as a moped.
And the statute requires that he's operating a motor vehicle. The definition for a moped only applies to whether or not you could get a restricted license.
Sure.
But
And
under
he's
motor vehicle,
clearly not 15 to 19 years old, so it
Yeah.
doesn't matter.
it was every vehicle that's
It was a motor vehicle,
self-propelled.
absolutely. And there was testimony that it was on the road. Doesn't matter how short or how long it does. It's for any brief time at all. If you're operating it on a roadway, it doesn't matter if it's for a millisecond. And so for that reason, as far as the moped goes, a moped is clearly. You said you drove it off, like you said it in your opening statement. You said it when you were testifying.
That's a commercial.
So it definitely wasn't a wooden, like one of those rocking horses or something like that. It was something that actually moves when you make it try to move and you push buttons or do something and it goes. So it was obviously a motor vehicle because you weren't pedaling it, you weren't Flintstoning it, and you weren't rocking. So it was motorized. And it was on the road. So your motion for directed verdict with regard to the definition that you're trying to come up with about a moped is denied. Your next reason for directed verdict, sir, is?
People have not met their burden because, as the U.S. Supreme Court said in Packer versus Banton, page 259, 44 Supreme Court Reporter, page 259. I have copies here to give I'll get one of these, prosecutor. The Supreme Court, their quote, you can tell it's right out of the law book, nothing I typed up on it. All right, the streets belong to the public and are primarily for the use of the public in the ordinary way. Their use for the purposes of gain is special and extraordinary, and generally at least may be prohibited or conditioned as the legislature deems proper. So, as they're saying, the legislature can regulate the use of the roads when it's being used for profit. As Borg admitted, he had no evidence that I was carrying passenger property for profit. And as the Supreme Court case right here demonstrates, I have the right to use the roads as long as it's not for profit. Since I wasn't doing it, I was not driving a motor vehicle. And also, I'm not done with that argument, so as an extension of part of that argument. All right, now the state statutes mention driving without a motor vehicle, use them terms, which is not a current. They don't give a real definition. I know they're doing that 20 years. I don't know everything, but okay, where is it at? I gotta go there. Let me get it to Okay, employment, and I got copies here, so you can see this right off the law book of enslavement and prosecutor. Okay, it's 18 U.S.C. section 31, subsection 6 and 10.
First off, let me make a ruling on your Packard versus Batten
Yeah.
motion. So you, under Packard versus Batten, they make a quote and there's a citation to it. It's cited in amongst other cases as well. State versus Johnson, 243 P 1073. There's Cummings versus Holmes at 155 P 171. Packard versus Batten at 44. Supreme Court 256. There's Hadfield versus London at 98. Washington 516. All of them quote to the same quote that originally comes from Hillhouse versus the United States, that says a citizen has a right to travel upon the public highways and to transport his property thereon. It doesn't say you can do it without a license. It just says that you have a right to travel, yes. But it doesn't mean, just because you have a right to travel doesn't mean that there is not a state's right under the health, safety, and welfare regulations to regulate those industries that have dangerous things. You can't drive a helicopter around. You can't drive a spaceship around. You can't, even a boat. Anything that could possibly run somebody over or kill somebody, you need to have a license. So you keep saying it. All these people on the internet like to keep quoting to it. And it's not what it means. Read the whole case. Yes, you can have a right to travel, but the state has a right to license you. So for that reason, the Bantam, sir, don't approach my bench. Don't ever approach my bench.
Excuse me. Well, thought I could do it.
Listen, trust me, you can give it to me all you want. I've read this matter 100 times. I've read every single one of those cases that I just quoted to you. Why? Because I'm fascinated by it. I too am a pure constitutionalist. And I almost want you to be right, but you're not. You can't just travel any way you want to. You can't do it in vehicles on public roads without a license. So for that, your Packard versus Banton, that's a misstatement of what the actual state of the law is. And yes, you do need a license. The Supreme Court of the United States has never said that you don't need a license. That federal statute has nothing to do with you driving on a road here in Michigan.
When I approach the bench, I show you this, so you can see word for word, they say what I just said about.
I want to hand it to Mr. Legislator. Mr. Hadley can give it to you.
The legislature only regulates it when it's being used for profit. They said that word for word. They didn't say nothing about only on.
Yes, I've read this. So the streets belong to the public and are primarily for the use of the public's ordinary way. Their use for the purposes of gain is special and extraordinary, and generally at least may be prohibited or conditioned as the legislature deems proper. You're literally proving my point. It literally says may be prohibited or conditioned as the legislature
when it's being used for gain.
No, as it means, it doesn't say that. It doesn't do it at all under the 14th Amendment. Mr. Hadley, I'm going to give you this.
Thank you, Your Honor.
That's why I read it into the record, because you're literally proving my point for me, sir.
Mr. Martin, your motion has been heard. The judge has made a legal finding on this.
Yep.
The court reporter.
Let's move on. Let's move on to the next one. Your USC.
18 U.S.C. federal statute made by Congress defines a motor vehicle different than.
Okay, hold on. This is my court recorder.
I have the copy too. I can give it to you.
My court recorder is making a recording. I want to make sure that, because you start to speak a little, you get a little excited, and you start to mumble and speak fast. I want to make sure that everybody can hear you and that she can make a proper record. So you were about to tell me that 18 USC, what was the next part of the
section? 18 U.S.C. section 31, subsection 6 and 10. Both of those define a motor vehicle as one only being used to carry passengers or property, which the evidence shows, and as he admitted, I was not doing. He doesn't have no evidence to say I was doing. Therefore, I wasn't driving motor now under Article 6 of the U.S. Constitution.
Can you see again? You're mumbling.
Okay, well, I'm just
so motor vehicle. The term motor vehicle, because I'll read it right.
Go ahead. Go read the term motor vehicle.
So it says motor vehicle. The term motor vehicle. This is literally ready. The term motor vehicle means every description of carriage or other contrivance propelled or drawn by mechanical power and used for commercial purposes on highways in the transportation of passengers and property, or property and cargo. Okay?
So,
Now, I'm gonna cut you off and add on.
sure.
Okay. We're cutting you off.
Now let's go down
Article
to, let's go down to paragraph 10
Right.
and get the definition of used for commercial purposes.
Right. Such as-
The term used for commercial purposes means the carriage of persons or property for any fare, fee, rate, charge, or other consideration, or directly and indirectly in connection with any business or other undertaking intended for profit. But you're talking about this section 31, and what is the whole section 31 about?
Now, well,
Exactly.
you just said it's about the definition of motor vehicle. Now, Article 6 of the Constitution, I'll point out, makes this, because Article 6 makes it clear, laws of the United States, which means federal statutes such as this, along with treaties and the U.S. Constitution, is supreme law of the land. So this definition is supreme over the state law definition, which doesn't say this. This is why I'm not guilty, because I wasn't driving a motor vehicle.
May I address that, Your Honor?
Please.
Yeah, so there is nothing that I'm aware of in the United States that I'm at least aware of that citizens of the United States or natural people or human beings can obtain a federal driver's license. The regulation of roads and driver's licenses has been left to the states with respect to the issuance of licenses and motor vehicle codes to be enforced locally and in the states. There are going to be a number of definitions for the word person, for the word corporation, for the word motor vehicle as it's applicable to any particular statute. And if you pick a federal statute that is applicable to motor carriers and it's defining motor vehicles and what's subject to those regulations, then that may be the definition. Sure. However, federal law only preempts local and state law where it takes up the space. And the federal government has not taken up a space with the issuance of driver's licenses to the citizens of the particular states. That's why you have different rules. Some you can get a permit at 15, some at 16. Sometimes you get a restricted license, sometimes all those things. It's different in every state. That's why.
Mr. Martin.
Object against
Mr. Martin.
Article 6.
Mr. Martin.
is supreme law.
Mr. Martin.
It says
Everything that Mr. Greco just stated is correct, and it's the reason why I'm denying your motion. Additionally, what you need to do is you need to go to you need to go to 18 USC, go to chapter 2 before you get to section 31. Because what it says, and actually what you need to do is you can actually go right to part 1, because let me give you the total thing so you can read the full statutory history. It's 18 USC. So that's Title 18, Part 1. Part 1 is all the crimes. These are all federal crimes. Every federal crime that you can think of, you can find in Section 18. So now we go to Chapter 2. Chapter 2 is aircrafts and motor vehicles. So every crime that you could possibly commit using an aircraft or a motor vehicle, a federal crime, is found in 18 USC Chapter 1, Part 2, and then you go to these sections. The first section is 31, and that's where you find your definition. So for everything we're about to say, for every crime we're about to talk about, here's the definition of an aircraft, here's the definition of a vehicle. And so you're going to find things like fraud involving aircrafts, violence against international airports, drive-by shootings. These are all things that the federal government has made a crime about, and they're defining just for those statutes that thing. The problem is, everybody on the internet who wants to be like, I got a right to travel, look at this, look what I found this, let's take this one statute out of context and just stand on it like it's Plymouth Rock. No, that's the definition for all the crimes that are underneath it. 31, section 31 is just a defining statute that defines all the terms that you're going to find in 31, 32, 33, and all the way down of all the crimes that federally they have, commercial vehicles that are required to stop for inspections, unsafe operation of an unmanned aircraft, aiming a laser pointer at an aircraft, all these different things that are crimes under federal law. That section 31 is only the definition for those, nothing else. It's not superseding state law. Why? Because under the 10th Amendment, anything that's not stated specifically in the Constitution reverts back to the states and its peoples. And Congress has made, like Mr. Greco said, has made no effort to say, look, we're going to create a national driver's license so you can just come and go anywhere you want. You know, you want to know why they didn't make a national driver's license?
I think
Because of Article 4, the privileges and immunities. When I go to Ohio, they can't arrest me for not having a license because I have a Michigan license. And when Ohio people come up here, we can't arrest them because they don't have a Michigan driver's license. Under the privileges and immunities, there's already a constitutional provision that allows for licensing, whether it's your license to carry a firearm, or whether it's your concealed weapons permit, or whether it's your, like hunting licenses and things like that. Sure, you got to go right to those states. Why? Because that's their state. They still have sovereign powers. They still have their own constitutions. So your definition from 18 USC section 31, you're skipping the two parts that are in between that. And those two parts that are in between that are part 1, chapter 2, which tells you exactly what 31 is doing. Okay. So for that reason, it's denied. You can take it up on appeal if you like.
Judge Slavin is smart, and he said he enjoys reading that, and you could tell, like he's just spitting all of that out. He's not looking at anything. And see, Eric Martin, like he said, he's helping the judge because he's quoting all of this stuff that makes no sense, but it's making sense in court. Crying shame what the sovereign citizens do.
Your next reason for directed verdict?
Yes, no, this is another case, Pickerton versus Berger, Michigan Supreme Court, decided in 1889. And I have the pages here to give to you, so you can show you the pages.
I don't need you to give me any copies of anything, sir.
584, quote unquote, they say, personal, this is the ball in the right to travel, personal liberty, which is guaranteed to every citizen under our Constitution and laws, consists of the right of locomotion, right, not privilege, okay, to go where one pleases and when.
Sure, and you just can't do it by car, denied.
They never said it, so.
You just can't do it by car.
They did not say that.
You can walk yourself anywhere you want to, when and how you want to do it. You can walk backwards, you can skip, you can do somersaults, you can cartwheel.
Yeah,
you can't use a car.
You can use a car or motorcycle. They're saying
that one's denied. Sir, you're not going to get argumentative with me. I've already told you that that's denied. That's not a legal argument. I admitted it. Yes, you have a right to travel. You can't do it by unlicensed driving of a vehicle.
Can I finish reading the Michigan Supreme Court code down on that?
No,
like halfway through.
Because that one's denied.
He's done with you now.
Same reasons that I've already denied.
I got other cases based on the same laws.
And it's going to be repetitive evidence, and you're not gonna just keep coming up with a different case that says the same thing, that says you have a right to travel. Because I admit, yes, you have a right to travel. You just can't do it by any sort of mechanical means that they need to license, whether it's by boat or automobile or helicopter or spacecraft or whatever the Jetsons thing would be. Any of those things, I'm sure you're going to need a regulation. Why? Because those things can kill people if they don't do it right. Walking, I don't know of anybody who's walked into somebody else and they ended up dying because they collided. So pretty safe with that. Riding a bike, yeah, same thing. So those methods, sure.
That's directed. Doesn't matter. Right, so it's about people's burdens. I think if you've got something that is a new argument about what they didn't do, if it's not, you've already made your appellate record. We've got a jury that if you do that.
Oh, I do want to, since you're not going
to.
So also, based on, I want to make another motion now to, based on you denying all my motions in violation of my constitutional rights.
That's incorrect, sir.
Well, this is, okay, I'm just stating my base anyways.
I'm merely making rulings based on the law. And so I'm not violating your constitutional right. Just because you don't get your way doesn't mean that you get your violation. This isn't kindergarten. This isn't kindergarten court. That's not how that works. We're not going to do temper tantrums with legal, frivolous things and stomp our legal feet with a bunch of arguments that have no relevance nor
substance at all. And then you just keep making it and making it and keep making it over and over until I get browbeaten enough to where I go, oh, you know what, Mr. Martin, I'm just going to dismiss the case. How about that? No, that's not going to happen. It has to be something. If you had something that was relevant, substantive, and right on point, I'd dismiss your case in a heartbeat because I've done it before with other cases. But you're not just going to keep bringing up the same, this case says I have a right to travel. True, it does. This case has a right to travel. Sure, it does. But that doesn't mean you can do it by not having a driver's license and operating any kind of motor vehicle. So do you have any other, do you have anything?
Different arguments here. Or
Do you have any different argument that's not, I have a right to travel?
Yeah, this one, okay, I move to dismiss this case based on Declaration of Independence of 1776.
You already did that. That was the second motion you made when you first started making motions. Next.
He eating them up and spitting them out. Like, just stop, Eric Martin. Just stop. You're done. You're done.
Well,
I think you may have reshuffled your paperwork, so I'm back up to the top.
I'm gonna move that you be disqualified from the case for denying my motions. I'm alleging that it was done in violation of the Constitution. Therefore, you should be recused from the case and dismissed.
Okay. Pursuant to Michigan Code Rule 2.003, any motions, I think it's C, any motions to disqualify are heard by the judge who's presiding, which is me, and I'm denying that motion.
Ooh.
Therefore,
That might be
request that you send it.
citation, but I think it is.
I request that you send this motion that you're denying to dismiss yourself to the state court administrator, which is supposed to be done by the court rules.
I did.
Have the state court administrator deal with the matter.
MCR 2.003, I'm thinking this is for disqualification, and it's heard by the judge that's presiding it, and I am denying that motion. You can take that up on appeal as well.
I think that's all the legal arguments I have.
All right, so
I think it's almost I said before the paper.
Your Honor, on the civil infraction, yeah, I was gonna say real quick before I pull it on the civil infraction, I can keep it, I can do
well,
it.
let's just do the civil infractions right now while they're already out.
Yeah.
So yeah.
So I think the testimony clearly established that he was operating with no proof of insurance. In fact, he had no insurance. So the evidence of that. With regard to the flat tire, it looks like he did have a flat tire. With regard to the
He said it in his opening statement. He even said to the jury, "Come on, really? If you're not picking at me, why are you coming at me about a flat tire?"
And he testified toward the end that he did not think during his sworn testimony, he indicated that he did not think he was operable toward the end because it was flat.
Yeah. So, and the report, when he ran the report on the computer, it came up that there's no insurance. So, anything you want to say about that no insurance or the?
I'm still looking for the MCL right now. MCL
on the
clearly
insurance,
makes it clear that.
Sir, if you take one more step, I swear I'll come over this bench.
Oh, again?
So Mr. Greco made the argument, they're closing this.
Yeah, okay, so, no insurance is required for the MCL I'm looking at right now, for a moped specifically, it is not required of a
No,
moped.
there isn't at all. But once you drive a motor vehicle, once you take it onto the road, because I also teach no-fault law at the law school. So once you take any motor vehicle onto the road, it has to be compliant with everything else is on the road. So that means you have to have insurance.
MCL.
The reason, and I can tell you the great case. The best case about it is a kid who's driving his moped on the road and he gets hit, and then his mom makes a claim with the insurance company and he gets denied. You want to know why? Because he's an uninsured motor vehiclist. As soon as he takes that moped on the road, boom. Same thing with people who take golf carts on the road. Boom. You better have insurance on your golf cart, because if you don't have insurance, like an actual, like the State Farm type motor insurance, as soon as it goes on the road, you're operating a vehicle with no insurance on the road. So
I have nothing further to.
Yeah, so that's no, the MCL right here, clearly says.
sir, you can take me up on appeal, but I just gave you my ruling of why that does not apply.
Your Honor, if I may, on the other civil infraction, I'm gonna make a straight preponderance argument. I would state I understand that there was,
I'm going to dismiss the tire one because I don't know what the tire looked like and I don't know what the tire, because if the tire can move, then is it defective? If it can make if I can drive on it?
That's my argument.
If I can drive on it, it's obviously not defective, because defective means it doesn't work. If I go to use my washing machine and I put clothes in it, and all of a sudden I push the button and all I hear is nothing moving, well, that's a defective washing machine. But if it washes my clothes, how defective is it? Even if it doesn't, like in a poor manner. So maybe it's a poor manner type of tire, but is it a defective tire? A defective tire won't roll. So
That's our argument.
dismissed.
Thank you.
So it's responsible on the no proof, dismissed on the tire.
And let's get Mr. Martin, let's get the jury back in here again.
So I do find you responsible on the no proof of insurance. That's $165 in fines and costs. I'm dismissing your defective tire citation.
Your Honor, Officer Borg, I think we're done with the testimony and everything, so Officer Borg does have to leave.
Officer Borg is free to leave if he'd like to leave, yes.
Thank you, Your Honor. Thank you,
Have a good day. All right, so Mr. Martin, your closing argument.
It took a lot of paperwork to find it.
All that paperwork, and it's not even worth anything.
Okay, so one, this court doesn't have, the so-called court doesn't have jurisdiction for this matter because Article 3, Section 2 of the U.S. Constitution.
Mr. Martin, I've already made a ruling on that. If you're going to give your closing argument as to the facts that were presented, please do that. If you're going to give some sort of legal argument that you've already given before, and I've already made a ruling on, that's not.
I understand. How am I going to make a closing argument? I can't cite the law. The closing argument deals with.
Your closing argument is about the facts that you presented. You presented facts. You got on the witness stand to talk about your facts, not any sort of legal arguments that have already been ruled on by me.
I don't understand.
You're more than welcome to have Mr. Hadley do your closing argument if you'd like.
I understand the defendant of all 20 years is allowed to make.
My understanding is that closing arguments are about the facts that were presented at trial, and you can talk about the facts that were presented at the trial and how that plays into your theory of the case. If you want to make motions to dismiss and things like that, which you've already made and denied, you're not going to just rehash those in front of the jury because that's not.
I'm not making motions. I'm making a legal argument.
You're not. It's not a legal argument. You know what, sir? Sit down. Mr. Hadley, you're going to do closing argument.
Ladies and gentlemen of the jury, thank you very much for your patience today.
He just got fired.
I know when you watch these on trial, TV trials, it's a lot more exciting. There's not this weird stop-starts. So thank you, sincerely. I know this has been an afternoon. Quite simply put, the people bear the burden of proof. You heard evidence today, and as the judge will instruct you, and it has instructed you, this is solely the people's burden. They must prove to you beyond a reasonable doubt, based on the actual evidence that's placed on the record today, that this individual violated the statute driving on a license revoked. Now, we can recap what we've heard today. We heard from the officer who testified more or less to his recollection of what happened. You can all make arguments that memories aren't perfect. You can speculate as to what actually happened that day. I mean, we do have the officer's testimony. He testified as to his recollection of what happened. You heard from Mr. Martin. We had our two witnesses today. He told you what had happened. Now, you heard no evidence that Mr. Martin injured, hurt anyone, ran a red light, speeded anything. It was, as he had stated on the stand, a victimless type of crime. So while Mr. Martin has, again, made some very interesting legal arguments to you today, what we really need to look at is, again, did the people meet their burden of proof? You know, was there enough evidence put before you today for you to make that decision? As co-counsel, the defendant, my position to you today is they haven't. It's a very high burden that they must hit. They have not hit that based on what they presented. So we'd ask that you return a guilty or a not guilty verdict based on what you've actually seen today. So I really, again, sincerely thank you for keeping an open mind as you go through this. Really, at the end of the day, I know that This is an individual who believes dearly in the arguments that he has made and the statements and the position he's taken. And with that being said, this is a statement that people have. I have nothing further. Just thank you for your time.
Mr. Greco.
Yeah, just briefly, I think the testimony of both Officer Ward and the defendant, Mr. Martin, we have met the verdict. They violated the law that day. I'm not going to go through it again. We can use the officer's testimony or Mr. Martin's own admissions and testimony regarding what happened that day and how he violated the law. He just disagrees with it. But as the jury, you need to apply the law to the facts as the judge is instructed. Thank you.
All right, it's time for them to make their decision. Well, when they come back, we're going to go through this last process. Eric Martin just totally, in my opinion, destroyed himself in court. So what do you think is going to happen? Is he going to be guilty or not guilty? As a matter of fact, you could timestamp that comment while you're watching it right now. All right, let's see. Do a guilty or not guilty? Put it in the comments. All right, let's keep it going.
This is the case of 231510, People versus Eric Martin. The jury has deliberated and is now back. Is there a foreman?
Sir.
All right. Mr. Foreman, has the jury reached a verdict?
Yes, sir.
In the case of the people of the city of Taylor versus Eric Martin on the charge of driving on a suspended revoked license, how does the jury find?
We found the defendant guilty, sir.
All right. And juror number one, juror number one, is that your verdict?
Yes.
Juror number two, is that your verdict?
Yes.
Juror number three was dismissed. Juror number four, was that your verdict?
Yes.
Juror number five, was that your verdict?
Yes, sir.
Juror number six, was that your verdict?
Yes.
Juror number seven, was that your verdict?
Yes.
Let the record reflect, if you're polling the jurors individually, that each of them has come to the same unanimous decision of guilty as to the driving on a revoked license. I'd like to thank and dismiss the jurors. All rise. Let the record also reflect that I'm going to place exhibit 1, plaintiff's people's 1, into the court file. We're going to set this for a sentencing date with a PSI, or we're moving for immediate sentencing today.
PSS. Gives the judge a sense.
Judge any sense of violation of the slavery or slavery. All this violation of the slavery. Agree to no sense.
That's not the question.
All right, so I'll set it for a sentencing date then. And I'm going to refer to a pre-sentence investigation report. And you'll be notified by the probation department, sir, to come in for the pre-sentence investigation report. And then you'll be able to read the report before the day of sentencing. You'll be able to go over that with Mr. Hadley. And we'll see everybody at that time.
I'm going to state it based on appealing the issue. Are we appealing it?
I can't give you any legal advice, sir.
I'm going to state it.
Sure.
Oh, the state assembly.
I just did. It's an oral motion.
The file gets served. Closing counsel. Closing counsel has a right to be served.
I request to be appointed appointment of counsel Slaven to appeal these issues. Well, everything's been denied in this court. Is the record still on?
No, we're off the record.
Okay, let's go back on the record.
You're going to get a PSI.
All right,
The case isn't done
I want to be appointed upon counsel to appeal the issues.
There's no appeal yet because the case isn't done yet. You haven't been
No, I said
sentenced.
we're appeal the issues that.
Well, you haven't been sentenced yet. Then after the sentencing, then the case is done, then you go to appeal.
I still have a right to interlocutory appeal the denials of my constitutional rights, my motions.
I can't give you any legal advice, sir. All I'm telling you is that you better show up for the PSI and for the sentencing date. Then you can do whatever you want on appeal.
This concludes this matter.
That was a lot of wasted resources for that one charge. And honestly, Eric Martin took most of the time up on this video because everything was pretty much done probably in the first 15 minutes with all of this extra stuff, the testimony, getting up there, going back and forth with Judge Slavin, didn't want to file all these motions. He's still found guilty. Now he wants to appeal it. So this thing is going to keep going on and on and on. But I'll try to keep up with it. So anyway, thanks for watching. I know it's been a long one. Hope you enjoyed it. It was a good video. I mean, got to laugh at him a little bit. Have a good day, evening, or night. I'll see you around on the next one.